Hi, I'm Eleanor Clarke, a Senior Associate here at Myerson in our Contentious Probate department, and I specialise in helping people challenge and defend wills. We usually deal with two main types of cases. The first is a challenge on the basis that the will is not valid, and the second is to challenge the distribution of the estate under the Inheritance Provision for Family and Dependents Act 1975. So let's look at the first way to challenge a will, which is to challenge the validity of the will. The most common validity challenges are as follows. If the will is a forgery or created by a mistake, if the person making a will lacks capacity, or if the person making the will has been put under undue influence by a beneficiary or another person. If the claim is successful, the estate will pass in accordance with any earlier will, if there is one. If there isn't an earlier will, then it will pass in accordance with the intestacy rules. The intestacy rules are set out in the Inheritance and Trustees Powers Act and determine who inherits what based on family connections. The rules don't take into account the closeness of your relationships or who is most in need, and there's no strict time limit for these kind of claims to be pursued, although delay can often cause significant problems. So if you do think that you might have a validity claim, then we recommend taking early legal advice, which of course we're here to help you with. The second route to challenging a will is by making a claim under the Inheritance Provision for Family and Dependents Act 1975, which we normally refer to as the 75 Act. Under this Act, certain categories of people are able to bring a claim for financial provision to be made for them out of the deceased estate. The categories of people who can bring these claims are as follows. The first category is a spouse or civil partner, someone that was married to the deceased when they died. The second category is children, including minor children and adult children. The third category is anyone treated as a child of the deceased, which might include a stepchild. The fourth category is cohabitees, someone living with the deceased as if they were husband and wife for the 2 years before the deceased died. The fifth category is anyone else who was financially maintained by the deceased at the time that they passed away. Different claims are treated slightly differently by the court. Spouses and civil partners are not limited in what they can claim from the estate. The usual position is that they can recover what they might expect to have received if their relationship had ended in divorce or the civil partnership had been dissolved rather than that relationship ending in death. And the starting point for this is normally a 50-50 division of the joint assets. In the cases of all other applicants, their claims are limited to what they need for their maintenance. It's not possible to claim for what might be considered to be a fair division of the estate, as maintenance only covers everyday housing and expenses at the usual and expected standard of living for the applicant. The time limits for these types of claims are quite tight, and therefore we recommend taking early legal advice. So this has been a very quick summary of how to challenge a will. In conclusion, the two main ways to challenge a will are the validity of the will or under the Inheritance Act. If you would like to speak to me or indeed any other member of our specialist team about potentially challenging a will, or if you are an executor who has received a challenge from a third party, then please do not hesitate to get in contact with us on 0161 941 4000, or you can email us at lawyers@myerson.co.uk.